Alrighty, good evening, everyone. Welcome to week 4 of constitutional law. Another big week in terms of a really important and really hopefully interesting couple of heads of power to look at in terms of the broadly what we can think of as international powers. They've got some sort of international element to them in the external affairs power and the defense power. So two really useful powers and ones that have seen or have contributed to significant expansions of Commonwealth legislative power over the years. Before we get into our tutorial questions and discussions for this evening, just a couple of quick bits of housekeeping. The first, hopefully you've had a chance to see the first assessment task up on Moodle. Excuse me. If you haven't already, if you log into Moodle and then under the assessment tab along the top, it's the first assessment task. And so there's a list of instructions and then there's a Word document that's got the task in it and it's got the questions baked into that as well. I've had a question sort of related to that, sort of more generally, on the issue of invalidity and how to deal with that. And I've posted an answer up on Teams. So if you haven't seen that one, check that one out. And then I've had a few questions about IRAC, so this issues, rules, application, conclusion, and how you might use it or whether you're required to use it in your assessment. So we're going to spend a little bit of time in today's tutorial talking through how do you structure your thinking, how do you plan an answer in a constitutional law problem, and then using IRAC or not. And then how does that filter through into actually developing a written response? So we'll talk through that in some detail this evening. The other bit of housekeeping is that today's census date. So tomorrow I'll be able to go in and we'll have as close to usually a finalized list of people who are enrolled in the unit as possible. And I'll be able to set up the allocations of the pairs for the second assessment task. And then I'll be able to release that one as well. So very much giving you plenty of assessment all at once. But this one you've got a little bit longer to complete. It's not quite as pressing. But yeah, so that'll be hopefully if Moodle is kind to me, I should be able to have all that up and running by lunchtime tomorrow. Maybe a little bit longer. It depends if Moodle wants to behave, but my aim is to have that by lunchtime tomorrow, and I'll make a post on Teams when that second assessment task is available as well. Before we get stuck into our discussion today, were there any questions either about assessment or about the week 4 content on these international powers?
I have a question about assessment.
Yes.
So we have 2 questions there addressing 2 acts. And the facts were given. Should we reiterate the facts by shortening them, showing our ability to deduce the meaningful legal part from the facts before we proceed with the analysis?
No. So I don't need a summary of the facts. What you can do in your discussion of the way that the law applies to the facts, you'll make particular mention of specific bits in the question or bits in the scenario that are relevant or that help demonstrate the particular point. But yeah, there's no need to go into a summary of the facts or a description of that sort of stuff. The word limit is too tight for those kinds of departures.
Okay, another question would be concerning the constitutional principles, which would equally apply in both questions. So, to my mind, it's better to cite only once, if we want to, certain constitutional principles we are basing on, rather than repeating them when addressing the second issue.
Yeah. So if you've got something that pops up across both questions, you can provide more detail in it in your answer to the first question, and then in your answer to the second one, you could say, this is also relevant for the same reasons as included in the first question. That's fine. Sort of just referring to above. Yep. Cool. Any other questions at this stage? Excellent. Alrighty. So for today's discussion, I'll give you a sense of where we're going, and then we'll dive into the question in detail. So this is, I've done up sort of how to go at how you might use the table, the answer planner. I've then color coding played out how that might look if you were using the IRAC method that some of you might be familiar with and comfortable with. And then I've gone through and done up just a sample written response. And again, the color coding to highlight how these different elements and subcomponents play out in the written response. So that's where we're going. And if we don't get through absolutely all of it tonight, that's fine. I'll be posting what I've done up on Moodle with the tutorial recording. So you'll have that as a reference point to come back to down the track as well. But the reason I want us to spend the time doing that is because the constitutional law answer planner, that table, and or IRAC are really useful ways of planning your response and thinking about the problem. But they can be a bit restrictive when it comes to actually writing your response. And often what we see is that people will, and especially it's more so with IRAC, because it's presented as these 4 headings, there's this instinct or temptation to talk about them as 4 equal sections. And the problem with that is that purely from a marking perspective, they're not 4 equal sections. Like identification of issues is only worth 10% of your grade versus your application and critical analysis is worth 40%. So your discussion of the way that the law applies to the facts is worth so many more marks. And so it needs to be a much more detailed discussion. And so I'm very much fine with you using IRAC to plan out your answer. And we'll talk tonight about how you might go about doing that. But just being really cautious of using it to actually structure your writing of the answer. It can lead you astray because it traps you into either not quite allocating the efforts where they need to go, or the rules and application sections, there's a real connection between them, right? The rules that matter because they apply to a particular factual scenario. And so often if you were just writing a response, your discussion of the rules and the application will really flow together. Whereas if you're structuring it out under IRAC headings, often what ends up happening is people will write the rules and they'll be tempted to just do all the application in there too. And then they come to the application section and they just sort of write, oh, well, I kind of already talked about this. So it applies in the way that I said it applied before. And it means that they're missing out on a lot of the nuance and the critical discussion that really needs to be in that section. So that's my overall caution about using these planners and using IRAC. I think they're really, really useful tools for thinking about a problem, but I'd encourage you to go that step further and try and move past them when it comes to actually writing your response. So let's put some of those ideas into practice, and we'll start off by thinking about the tutorial 4 question. So I'll share my screen for that one. And so our scenario for this afternoon takes us to the far future of 2057, where there's widespread use of robot-like devices called avatars. And there's this concern about the danger of using these avatars for manufacturing, but also for their use in warfare. An International Committee of the Red Cross convenes an international conference in Geneva, and the conference endorses a draft convention on the use of these avatars. There's a preamble saying, if you sign up, you sign up. Article 9 provides that the use of avatars for military purposes must be strictly supervised, and that states can enact any regulations necessary to achieve that end. Article 10 provides that the avatars are not to be used at any stage in the preparation or deployment of large-scale armaments. The Commonwealth Government has noted this concern, but they're also actually pretty keen to see what Australia could do with them in the military. So they pass the Humanoid Avatar Responsible Use Act, and that passes on the 2nd of February 2057. So we're assuming that the Constitution doesn't change in the next 30, 40 years. Section 14 provides that the use of avatars in dangerous work is prohibited unless strictly supervised, and the definition of dangerous work includes civilian or military context using tools, machinery, or equipment that poses a serious potential risk to workers or public safety. Section 15 empowers the Minister for Defence to establish a government-owned Australian avatar factory for the purpose of manufacturing safe, technologically advanced avatars for civilian, military, and commercial use. So our questions for tonight are sections 14 and 15 of the Act authorised by the External Affairs Power, or are these provisions authorised by the Defence Power? Would it make a difference if Australia was engaged in protracted international armed conflict? So, a nice detailed scenario there, plenty for us to think about and to sink our teeth into. So I'll pull up the answer planner and we can start thinking about what might be useful for us to include in our discussion. So what's immediately leaping out to you as being interesting or useful or relevant in this scenario?
Legislation which this section authorizes.
So I missed the first part of that. What did you say?
Yes, 3 types of legislation this section 51 authorizes. I'm talking about powers: geographical power, the treaty power, and international relations power.
Okay, yep. So thinking about the external affairs power, we've got these 3 limbs. Yep. Sorry, matters external. Yep, absolutely. What else?
Whether for Australia, the matters raised by the International Red Cross are the matters of international concern.
Okay, yep. So is this of international concern? Yep. What else?
The status of the convention itself. It is said that this is open for accession, for signature in a certain month of a certain year. And we need to compare that term with the date when Commonwealth laws have been adopted.
Yep. Okay. So yep. What else? And I mean, I don't want to detract from the excellent work you're doing, Vladislav. Does anyone else want to weigh in as well?
The wartime versus peacetime power of the defense power.
Yep. So in terms of thinking about defense, we're thinking about sort of, and which is broader?
The wartime one.
Yep. Absolutely. What else?
For which purpose? The avatars, which are regulated by Australian legislation, are used for civil, commercial use, or for wartime, for military purposes. I think that subtlety should be picked up.
Yep. So in thinking about what, and we'll look at the specific sections as we go through, but thinking generally, there's this sort of the legislation tries to get at both, but if we're thinking in terms of the defense power, that might be problematic. Yep. Awesome. What else?
I think it's interesting that the defence power that's held by the Commonwealth, yet they're sort of delegating the supervisory requirements back to the states.
That's a good point. The thing that's tricky when we're dealing with international laws and international relations is that in the international sphere, nations get referred to as states, and so the reference in an international treaty to a state should be read as a reference to a country,
Okay.
rather than Queensland. Yeah, it's a good pickup, because at first it doesn't quite make sense, but it taps into these ideas of sovereign states rather than Queensland, New South Wales, Victoria, etc. But yeah, good pickup. But yeah, we are just dealing with the federal level on this one. So we've honed in a bit on this idea of treaties and potentially there being issues around signatures and things like that. What are some of the interesting ideas that we should be picking up from the Tasmanian Dams case about the use of implementing a treaty as falling under the External Affairs Head of Power?
Whether Australia tries to implement this convention.
Yep. So does it implement the treaty? And what else?
Regarding the limitations to the treaty's power, I guess.
Yeah, tell me more.
Like if the agreement is bona fide or if there is any legislation by the Commonwealth that is, related to the treaty.
Yeah. So so in terms of thinking about whether the law in fact implements the treaty, there's got to be that connection. Yeah, absolutely. There's a second step that we need to be thinking about. It's got to be, we've got to have more than just the implementation, or we've got to think about more than just does it implement the treaty. We've also got to think about
The nexus requirement.
Sorry, say that one again.
The nexus requirement.
That's a separate issue that sort of goes more towards pops up more with the other limbs. The other thing that we really have to think about is whether the implementation is proportionate. Right? Is it appropriate and adapted to the purpose or the aims of the treaty? So it's and to pick a ridiculous example, let's say Australia signed up to a treaty that we're concerned about the international community is concerned about the prevalence of wildfires and bushfires, and so countries agree to take steps and efforts to help each other reduce these incidents of wildfire and bushfire. And so Australia passes a law requiring that every tree in Australia gets cut down. It implements the treaty, right? It would stop there being any bushfires, but it's just so out of proportion to what's actually being tried to be achieved that it wouldn't be valid under the external affairs power. So this issue of proportionality, whether it's appropriate and adapted, is something that we need to really think about in terms of this these bits of legislation as well. Excellent. All righty, let's press on and think about section 14, which is the section on strict supervision of the use of avatars in dangerous work. What, if we're thinking about the treaty, what would the Commonwealth argue? What article of the treaty would the Commonwealth argue that that's implementing?
Article
By
9.
having,
Yep. So Article 9, and then I couldn't see on the screen. Someone else wanted to weigh in as well.
I don't know if that might be Article 9. What I'm going to make, yeah, the military use by strictly supervising use in the military.
Yep. And does section 14 implement that? Does it provide for strict supervision of the military use of these avatars?
Yes.
Yep. So it and it's on my other screen, so I can't read out the exact words, but it provides for dangerous work.
Civilian or military context.
Yeah. So we'll talk about the civilians in a minute. but in terms of step one, does it implement the treaty? Yes, because it requires that dangerous work needs supervision, and dangerous work includes military application. So there's, in terms of implementing the treaty, Section 14 does what it needs to, but thinking about proportionality and whether the Section 14 is appropriate and adapted to the aims of the treaty, we've got this issue with civilians, right? Is the requirement that that the civilian use also be strictly supervised, is that appropriate and adapted, or is it an overreach? Is it going too far in what was contemplated? Because the convention or the treaty focuses on wartime, and so arguably the scope and the use of the external affairs power, that implementation, should be similarly restricted and narrowed in focus as well. If you were the if you were representing some sort of civilian manufacturing group and you wanted to get these laws struck down, you'd argue that it's an overreach. You'd say that it goes beyond what the purpose is. If you were the Commonwealth, what you might do is you might focus in on the wording of Article 9 that allows states to use any regulations necessary, and these ideas in the that are provided in Section 14 definition of dangerous work as these ideas around threats to public safety. You might try and argue that restricting, because of the wide scope of use of these avatars and then the potential problems that they could cause, extending these regulations into the civilian context is necessary because it and it's appropriate and adapted because it ensures that even in the civilian context, it's not going to spill over into military application or acts of violence in the public sphere and those sorts of things. It's not as strong an argument, I don't think, compared to the argument that this is an overreach. The treaty says nothing about civilian or commercial use, but if you were the Commonwealth, that's what you'd put forward. So let's now sort of, we'll circle back to more of these other ideas as well. But in terms of thinking about how you might be using IRAC to further extend some of these ideas, I've sort of color-coded these tables a bit in the ways that they line up with IRAC, and basically your yellow sections will be your rules. So you'll be setting out the heads of power that you want to draw on, and then the relevant tests and cases that help us understand and interpret those powers. Those are your rules. So setting out basically Tasmanian dams in this instance and the important things that we need to be thinking about in relation to that. And then coming down to that application, the application sections themselves line up pretty well. And so you can sort of see if IRAC is something that you find really useful and is a strategy that you find helps consolidate your thinking, you can use this table to help inform your use of IRAC as well. Let's talk about, let's stay on external affairs, just to keep things simple, and let's talk about section 15. So what, if you were the Commonwealth, what treaty provision would you argue section 15 implements? Or is it just completely not even close to anything? So let's start with characterization then. What does section 15 do? What's it about?
It allows the Minister of Defence to establish like an avatar factory so that they can manufacture them for civilian, military, or commercial use.
Yep, absolutely. So, and what does Article 10 of the treaty provide or attempt to restrict?
That during the preparation or deployment of them, they can't use large-scale armaments.
Yep. So there's this inconsistency in that the section 15 tries to set up manufacture of these avatars for military use, and Article 10 says, you know, if we're engaging in large scale military armaments and operations and things of that ilk, avatars can't be in that sphere. And so there's an inconsistency here. So we would have a lot of trouble arguing that that section 15 implements the treaty at all, because there's this severe inconsistency between what section 15 is trying to do and what Article 10 aims to try and prevent. Before we move on from the external affairs power, I did just want to revisit Vladislav's comments about the timing of the treaty as well. So the conference takes place in August 2056, and the conference endorses a draft convention to be opened for signature by states in 2057. Meanwhile, the Parliament has passed this legislation on the 2nd of February 2057. So the key bit that we're missing here is that it's to be opened for signature by states so they won't be able to sign until June 2057. But here we're trying to pass the law implementing the treaty before that even occurs. So that's a really great pickup there. What it means that at the moment for this sort of, what is it, a 4-month period between February and June, the international, the implementing the treaty limb couldn't sustain this legislation. But after 2057, if Australia signs, then would be able to make use of it. So it makes sense in a discussion to consider all these issues around, is the implementation proportionate? Because in the context of just a couple of months, all those issues would become live again anyway. But that's a fantastic pickup there, Vladislav. So well done on that one. We'll revisit external affairs when we come back to thinking about the overall validity of this legislation and some of the conclusions that we might reach. But before we move on to the external affairs power, from the external affairs power to defence, were there any other questions that people had about external affairs?
I've got a question.
Yeah.
So are the articles and the sections, do they sort of link up ordinarily, or?
As in, would you expect to see one-to-one matches of articles and sections in law a lot of the time? Is that sort of what you mean?
Yeah, like are the treaties articles the same to the sections of the legislation?
It can depend. You just mean sort of in general?
Yeah.
Yeah, it can depend on what the treaty is. Sometimes what will happen is that it's the legislation reproduces the wording of the treaty, depending on what it is. Other times, if the treaty is something that's a bit more, so take something like the climate change goals, reducing climate change, right? There's the overall goal, but then it's up to the individual countries to figure out how they're going to achieve that and what domestic measures they're going to pass in order to hit those targets or whatever. And so with something like that, because there's that domestic flexibility to pursue whichever policies they think are best, you wouldn't expect to see that exact matching. Whereas something that's a bit more concrete, so statements of rights. We don't have a Bill of Rights in Australia, so it's not an amazing example, but statements of rights or really concrete obligations or responsibilities that a nation takes on, you might expect to see the wording either reproduced or more closely matched to what's in the treaty. You wouldn't, even then, it might get broken down slightly differently into across different sections just to spell things out a bit more clearly or to take into account domestic variations. But that straying from that and that variation wouldn't necessarily be a problem or make the implementation disproportionate, as long as overall it was consistent with what the treaty was trying to achieve. Any other external affairs questions?
Also geographical power, by arguing whether Seas and Submerged Lands Act case is applicable here. I'm talking about matters geographically external to Australian territory. And we don't have sufficient facts that something bad in relation to avatars happened already externally. So this Avatar Act passed by the Commonwealth doesn't relate to matters, things or events physically external to Australia.
Yeah, I think that's the right interpretation there, is that there's nothing on these facts to say that there is that connection to something external. There's not even even following something like Polyukovich, where the acts were committed overseas, but then he moved to Australia. But Australia's participation in World War II was enough of an external nexus. There's nothing. We're not given enough in this scenario to make a compelling argument for that first limb. I think that's the right approach. Absolutely.
Perhaps the very last thing would be international relations power, the Crown and Sharkey case. So relations of the Commonwealth with all countries outside Australia are matters which fall within the subject of external affairs.
Yeah,
And the Avatar Act doesn't concern relationship with other countries.
Yeah. Again, I think that there's not enough on the facts. If the facts themselves were, if it was something like Australia's key allies in the US and UK and New Zealand or something, they were really concerned about the use of these avatars or something like that, and there was pressure from those countries for Australia to ban or restrict the use as well, then maybe those facts push us towards something like that. But yeah, on the scenario that we've got in front of us, there's not enough to really sustain a deep discussion of those limbs. Absolutely, we're guided to discussing that treaty limb. Excellent. Alrighty, let's talk about the defense power, and as we've noted, the scope of the power expands and contracts depending on whether Australia is at war or not. Another way of thinking about that is looking at the Communist Party case and Justice Fullegar's distinction between the core or the primary aspects of the defense power, which include things like preparedness, recruitment and training, manufacture of weapons, all these sorts of things, which is in the primary sphere of what's envisaged in the defense power, and so will sustain laws with respect to defense in war and in peace. And then we've got these secondary aspects which still have some connection to the defense of Australia, but are not within that core. And so during peacetime, you wouldn't find those secondary elements being sustained by the defense power. But in war, when the scope is expanded, we would see more of these broader or more generalized laws affecting economic and social conditions and things like that in this secondary sphere being justified or valid under the defense power. So the reason that that's interesting and useful, and I'll just add to frame our discussion as well. So let's jump to section 15 first. We've already said that it's problematic under the external affairs power. And we've characterized it as being for this manufacture of avatars for civilian, military, and commercial or all commercial use. Do we think that might fall within the primary aspects of the defense power or the secondary aspects of the defense power? This idea of we want to build these avatar robot death machine things.
Probably the secondary.
Okay.
Because it's not specific to military only. It sort
Yep.
of incorporates civilian and commercial use as well.
So let's do this, right? Let's talk about it in the military context, and then let's talk about it in the civilian and commercial context. So if it was just military, if Section 15 just said empowering the Minister for Defence to establish a government-owned Australian avatar factory for the purpose of manufacturing safe, technologically advanced avatars for military use, how would we feel about it then? Primary or secondary?
Primary.
Yep. So we've got this sense that, and it probably falls most likely under these ideas of defense preparedness. If there's this international worry that these avatars are going to be used in war and in a military setting, then Australia wanting to be at the cutting edge of this technology, figuring out how to manufacture it and develop it, seems very much to fall under this primary aspect of defense preparedness. Potentially, there's an analogy to the manufacture of weapons and those sorts of things. So I think we'd have a pretty compelling argument that the military application, at least, falls within the primary aspect of the defense power. What about the civilian or commercial uses? Evan has sort of suggested that might fall more within the secondary aspects. Does anyone have a different view or supports that view?
Are we analyzing now the defense power in peacetime?
Yep. Yeah. So let's talk about peacetime first, and then let's think about it. If the answer would change, if it was in war. So in the chat, a vote for secondary as well. Yep. It seems to just be that little bit further out, and lacks that really direct connection to these ideas of defense preparedness and things like that. So if we're in peace, are we thinking that means that it wouldn't be sustained by the defense power?
I don't think it would in peacetime.
Yep. What about then in wartime? Would our answer change? And if so, why?
Yes, it would change.
Yep. So if we're at war, then it might be supported. Why would that be? Because even if something's in this sort of secondary element, it's not an automatically valid under the defense power. What's useful and important about this civilian or commercial manufacture of avatars if we were at war?
They can contribute to war effort as well, indirectly.
Yep. So the commercial application or use of these avatars could contribute to the war effort.
And in war, the Commonwealth reach can extend into civilian matters as well.
Yep. So this idea of regulating the economic and social conditions, as long as there's some connection back to the war or the war effort. We might also think about things like the women's rights employment cases. And again, thinking about the idea that the avatars themselves might be able to be doing things in a commercial setting that contribute to war, so building bombs or whatever else. But they might also be able to do manufacturing jobs that free up humans who are doing those jobs to join the army and contribute more directly to the war effort themselves. So there's sort of a double argument that in wartime, the commercial or civilian use of these avatars could be really important to the war effort, and so would be sustained under the defense power.
And if they were to pose a threat to the security of Australia in wartime, that would I was reading that the Minister for Defence has powers in wartime as well under the Constitution.
Yeah, so when you say if they were to pose a threat to Australia, do you mean if the avatars themselves posed a threat, or?
Yeah, like I'm probably getting a bit sci-fi-ish here, but yeah, if we're talking avatars and robots that are controlled by computers, then cyber security is a big issue, you know, in our current climate. Then it would be possible that the avatars could be hacked.
Yeah. I like the direction that you're going with it, but I actually want to take it to section 14. The reason being, for one, it provides for strict supervision of these avatars, and so I think that, you know, if there are security concerns, that's really interesting and useful to have that discussion in the context of these supervision requirements as well. The other thing that's interesting about section 14 is the wording around supervision of avatars doing dangerous work, and dangerous work being something that poses a threat to public safety. If you were the Commonwealth and you were trying to make as broad an argument as possible to get these laws valid, what you might do is try and draw an analogy to Thomas and Mowbray. So this was the case involving anti-terrorism laws, and the argument being that the defense power includes the ability to protect against domestic threats. What the Commonwealth might try and do with both powers, but especially section 14, is argue that this strict supervision, even in the civilian context, is that because these avatars are being used in a setting that might pose a risk to public safety, that's a domestic threat that the defense power would enable the Commonwealth to have oversight over. The neat thing about that argument as well is that that's something that is within the primary aspect of the defense power, this ability to protect against domestic threats. So that's something that would be available in both wartime and peacetime. So that's potentially useful. It's not a weak argument by any means. I think it's definitely a plausible one. But it's held back a little bit by the fact that the wording around public safety is a bit broad, and it doesn't necessarily directly get to the idea of protecting against violence against the state or domestic acts of violence, these sorts of ideas. So it's not a home run by any means, but if you were the Commonwealth, it's an argument that you'd put forward, is that you'd say that this public safety element is that the Commonwealth needs to be able to supervise these robots when they're posing a threat to public safety in order to ensure the defence of the Commonwealth and the people of Australia. That's the argument that you'd put forward. Any questions on those ideas? We've sort of bounced between sections 14 and 15 a little bit there. But I want to make sure that we've got a couple of minutes to talk about the conclusion and how we draw all of this out. But any defence power questions before we do that? No, that's great. Sorry.
I have just confirmation, seeking confirmation from your part concerning these conditions of employment in industry generally. This thing, which is the secondary aspect.
Yep.
Under the Australian Communist Party case. So here we established that's regulating the usage of those avatars for the purpose of safe work, that these may fall under this second aspect.
Do you mean for section 14 or section 15?
I mean 14.
14. I think you'd be right to say, well, and this is why characterization is important, right? If we characterize section 14 as being a section in putting aside the military, the supervision of the avatars in the military setting, if we just focus on civilian use, if we characterize this as a law with respect to regulating conditions of employment, I think that does fall into that secondary category, and so in peacetime it wouldn't be sustained. If we characterize it as a law with respect to ensuring public safety and protection against potential acts of violence that these avatars might partake in, even in civilian usage, then that opens up the Thomas and Mowbray argument, which is in the primary aspect, and so could be sustained either in war or peacetime. And so, we've said that it's not a guarantee that that's a strong argument, but it shows why that characterization is important, because if we see it as this is just about employment, it really narrows the scope of what we can argue, or what the Commonwealth could argue, and in turn would really hinge on whether Australia is at war or at peace for that one. Does that make sense? Fantastic. So let's talk about the validity of these sections then, and pulling together some of the ideas of severance. And if you haven't had a chance to look at my discussion of severance in teams yet, I'd recommend that you check that one out as well. But so basically, let's say that the signature thing is not an issue. Let's say that the signatures have opened earlier. Australia is a signatory to it. What we might say is that Section 14 is partially valid, in that the restriction for or the requirement of supervision for the military setting implements the treaty and is a valid implementation of the treaty. So that makes it valid. And so even if there were problems with the defense power, let's say, it would be valid under section under the external affairs power. The problem with the civilian elements under the external affairs power, we've sort of said maybe that's not proportionate. It goes too far. Let's say that is the successful argument and that is the case, then that would be a disproportionate implementation of the treaty, and so it wouldn't be valid under the external affairs power. Let's say that the Thomas and Mowbray argument is unsuccessful as well. That means that attempting to regulate the civilian use of these avatars wouldn't have a head of power to attach to, and so it wouldn't be a valid exercise of Commonwealth power. What the court would do in that instance is they would sever the invalid parts and they would retain the valid parts. So section 14 would just become avatars used in dangerous work need to be supervised. The definition of dangerous work is use in a military setting, and the other bits about the civilian use get cut out. They go. So if you were using avatars in a civilian setting, you wouldn't have to follow that strict supervision requirement because it's not constitutionally valid. Same thing with section 15. We've suggested the external affairs power is just not going to work here, so that's gone. The military use falls within the primary aspects of the defense power. We'd seem pretty happy that would be supported. And so if that's the case, that element of section 15 is constitutionally valid. The civilian elements, we've said, fall within the secondary aspects. And so if we're in peace, they wouldn't be validly supported. So again, we're looking at severance and we're severing the reference to civilian and commercial use. But the valid part, which is the manufacture for military purposes, gets retained, and that becomes the operational part of section 15. The invalid parts get deleted, cut away, put aside. And so what that would mean in practice is that the government would be able to still set up this manufacture of the avatars. They could set up this factory, but they could only use it for those military purposes. They couldn't use it for the civilian and commercial purposes as well. So that's a very whirlwind application of the severance and honing in on these ideas of the legal and practical effects of the validity of this legislation. Any questions about those ones before we wrap up? Excellent. All righty. Well, we'll leave it there. As I said, I'll post up tomorrow with the recording a version of this that has more detail, goes through how that translates and looks if you're doing an IRAC plan, and then takes the further step of mapping out how you would actually go about discussing that in a in an answer that you might use in an assessment setting. What I've done, I've mapped it out clearly for the external affairs power, and then I've scaffolded the defense power. So there's, you know, I'm getting you to sort of do the work a bit more there. The reason being, because the discussion of the rules in particular becomes a bit formulaic and can be used across multiple settings. Perhaps I don't want to give you a word for word answer about how to address the use of the defense power. Hint, hint, maybe that's something that you'll be wanting to do for yourself in the assessment task. So I'll leave it there, but if you've got questions as you go about completing that element of the defense power write-up, please do feel free to get in touch. But I will leave it there. Thank you all very much for coming along, and I'll see you all next week to talk about section 109, inconsistencies between federal and state powers. So looking forward to it. I'll see you all then.
Thank you.
Thank you.